Are you familiar with the American Axle and Manufacturing versus Neapco Holdings case? If not, you may want to pay some attention. We're going to do a multi-part series regarding this case. Procedurally, where it stands is that there is a petition for certiorari that has not yet been decided upon by the U.S. Supreme Court. Hello, I'm George R. Meyer. I am a patent attorney and have learned much over my 30-year patent journey. Along the way, I've learned many tidbits and would like to share them with you. We will cover many of these in upcoming videos. Subscribe to this channel to make sure that you do not miss any. So let's turn to today's topic. We're addressing American Axle and Manufacturing versus Neapco Holdings. And this is the first part, and the question at the end is whether or not the claim at issue in American Axle and Manufacturing is closer to the patent claim in the Morse patent or the patent claim in the Diehr patent. What you'll discover is that many are dissatisfied with the Federal Circuit's decision in American Axle and Manufacturing versus Neapco Holdings. There have been a lot of people that have been saying, how can you possibly have a mechanical invention not qualify as patentable subject matter? Now, the big unknown is whether the Supreme Court will grant certiorari, and if so, how it will decide the case. Now, practitioners may need to reevaluate application drafting after a final disposition or decision on the case. Okay, let's do a quick technology overview of the patent that's involved in the case. Now, this has to do with a propeller shaft, and what we're showing is a frame of a vehicle, and going from left to right, we have an engine 14 that's coupled to a transmission 18. That transmission is coupled to the propeller shaft 20, which is then coupled to a differential, and obviously the rear wheels will be driving the car. Now, there are three types of vibrations that are involved in this application. There is bending mode, which is generally vibrations that travel along the length of the propeller shaft. But there could also be shell mode vibrations, which have to do with distortion of the shape of the tube, as well as torsion, which is related to twisting action. So in the disclosure, this is what the propeller shaft looked like. And notice it is between the universal joints, which I think those are items 212 near the left-hand side and 214 near the right-hand side. So as you can see, the propeller shaft is a thin hollow tube. It's usually made of steel or an aluminum alloy. But it can bend and flex and do some types of motion. So in order to reduce the vibrations, the inventors are talking about inserting one or more liners, which I have colored in green, within this propeller shaft to reduce vibrations. Now, this is what one of the liners generally looks like. The liner has a structural portion which is made of multiply cardboard and a lip member. As you can see, it goes helically around the structural portion of the liner. And I will point out that from what they describe in the patent, it seems like one of the prior art liners which is discussed in the patent application seems to be similar to this. But the mere fact that it's similar in construction doesn't mean that it's covered by the claim that we have in this patent application. Now here's a close-up view of how that lip member is made, and what we have is an elastomeric material that makes up that resilient member 302. The lip portion is part of it that sticks outside of the liner, and you have generally an anchor portion that would correspond to, for example, reference 320 that keeps that in place. Now, the liner itself has a number of layers, and you can see it has a core 310, a couple of intermediate members 312, and a cover member 314. And those three components, 310, 312, and 314. That makes up most of the liner, and much of the disclosure is focused on adjusting the mass and stiffness of the liners, 204, to address vibration mechanisms. Okay, let's take a look at Claim 22 in the patent. Now, I've taken off most of the text of the preamble, so I went pretty much straight to the body of the claim. So what we have is providing a hollow shaft member, tuning a mass and a stiffness of at least one liner, and inserting the at least one liner into the shaft member, wherein the at least one liner is tuned to absorb shell mode vibrations and tuned for destructive interference of bending mode vibrations. These words are not exactly what shows up in the patent. That part that says to absorb, they actually refer to resistive attenuation, and where I have destructive interference, they refer to reactive attenuation. But resistive reactive starts sounding close, and also I think it's easier for people to picture this talking about absorbing vibration or generating destructive interference to cancel out the vibrations caused by the propeller shaft. We have two different vibration modes. What they state in the patent is that in the prior art, everybody optimized on only a single type of vibration, whether it would be bending or shell or torsion, but they didn't optimize based on more than one of the vibrating modes. Also, the attenuating mechanisms are different. One is absorbing vibrations, the other one is generating destructive interference to reduce the overall vibrations. And based on the arguments, especially when you start reading the rehearing opinion, you get a general understanding that people knew how to tune these liners. So they knew you were going to need to use Hooke's law, and much of the discussion centers around, is American Axle Manufacturing trying to preempt the use of Hooke's law in tuning the liners. Now, for those that may not remember from physics, Hooke's law is related to the spring constant, that a force is equal to the spring constant times the displacement of the spring itself. Now, it gets much, much more complicated and has many other dimensions that can come into play. If you like, go onto Wikipedia and take a look at Hooke's law, and you can see it gets really, really complicated from a math standpoint. But it really sounded like everybody knew you were going to be using Hooke's law, so there's nothing unusual with that. Let's compare this to Claim 8 in Morse's patent. Now, Morse's patent is the telegraph patent, and this is decided by the Supreme Court, and they focused on Claim 8 as far as invalidation. Now, we have a lot of words here, but I'm going to focus on what would be the heart of the claim, and that is the use of the motive power of the electric or galvanic current, which I call electromagnetism, however developed, for marking or printing intelligible characters, signs, or letters at any distances. And the big problem was the words, however developed. Now, other independent claims in Morse patent were omnibus claims, and they were held to be eligible. Well, how do you convert this to an omnibus claim? Take out however developed and stick in the words as substantially illustrated and described herein. For an omnibus claim, you're going to be limited to the very specific techniques that you described and illustrated in the patent. That's it. Let's take a look at Claim 1 in Diehr's patent. Notice the length of the claim, much, much longer. Now, we have two constantly steps, but really all they're talking about is you have a thermocouple coupled to a computer. Now, in this, we have an equation. It's about 3/4 of the way down. You can see it's the natural log of V, which is the calculated cure time, is equal to CZ plus X. Now, if we go up earlier in the claim, we can see that C is going to be a constant. It's the activation energy constant that's unique for the molding compound. My guess is this is probably a vulcanization or other type of reaction that's going to occur, and there is a constant that's dependent upon the geometry of the particular mold press. So as we can see in that equation, we have a couple of constants, and the only variable z is the temperature. Now we have a lot of things in here, and I will point out that there are a number of courts, they have not yet held this, but I have seen a few Federal Circuit cases where judges have questioned whether or not providing is truly an active step. And I've had one client tell me, do not use providing. If you have anything in the providing step, or whatever you want to call it in this claim, don't use that. Move it down to where it first is introduced in the active steps. So really, if you get down to this, and this is my opinion, we have 4 steps in Diehr. The first one is about 40% of the way down, and that's initiating an interval timer. So you're going to have this timer that's going to go off in intervals. Okay, we skip the constantly steps and go to the repetitively performing in the computer. All this is doing is taking a temperature reading, and then from there determining the calculated time for curing. And it's using the Arrhenius equation. The next step is comparing that calculated time to the elapsed time. And based on that outcome, you're either going to go back and do another interval of the timer, or you're going to open the press. And opening the press will stop the reaction. We have 4 steps. You start an interval timer, you take a measurement from which you can calculate a calculated time. After that, you compare it to the elapsed time, and then you make a decision whether or not to stop the process. Now we turn to likely considerations at the Supreme Court. If certiorari is granted, the case law involving the physical and chemical sciences, as opposed to software, will likely be closely examined. Now, this doesn't mean they won't be looking at any of the software cases, but most of the arguments that have been made very harshly against this case is it's a mechanical invention, and it should qualify as patentable subject matter. So if the Supreme Court's going to take it head on, they need to address these physical and chemical sciences cases. Now we have from O'Reilly versus Morse that Morse's Claim 8 was invalidated. And remember, that was electromagnetism, however developed. But in the same case, the omnibus claims were held valid. And again, we mentioned this a little bit earlier. Courts tend to like it if a party partly wins, partly loses, as opposed to they win everything or they lose everything. Now from Diamond v. Diehr, the USPTO rejection of Diehr's Claim 1 was reversed. So in other words, the Supreme Court actually affirmed the CCPA's reversal of the USPTO rejection. And this was the use of the Arrhenius equation in a rubber curing process. So we think that there's going to be an awful lot of debate where it's going to be, is Claim 22 an American Axle and Manufacturing's patent closer to Morse's Claim 8 or Diehr's Claim 1? This will not be the turning point, but there is going to be a fair amount of argument that the American Axle people will be arguing that Claim 22 is very close to Claim 1 in Diehr. It's basically the application of a natural law to a practical process. On the other hand, Neapco is going to be arguing that Claim 22 is invalid because it's similar to Morse's Claim 8. But what they're going to need to show is that basically American Axle's Claim 22 effectively preempts all practical uses of Hooke's law in tuning the liners. So it's kind of a tough road to hoe, but it's a Supreme Court. They're not exactly the most patent-friendly court, and they do have, unfortunately, a history of blending in other sections of Title 35 into 101 analysis. So unfortunately, they may bleed parts of 102 case law, parts of 103 case law, parts of 112 case law, as well as those statutes, into their considerations on 101. So anyway, that's where it stands, and we hope that you will be following this along. And remember, at least for this video, give us a like and leave a comment. Remember to subscribe to this YouTube channel, or better yet, sign up for our email list at georgermeyer.com and get a freebie. Currently, the freebie is my dependent claim equation. Many have told me they wish they had the equation earlier in their careers. It's that good. Follow us on LinkedIn, and thank you for your time. Check in a little bit and we will have the next part in this series on this YouTube channel. So we'll see you next time. Thanks. Bye.